Morning, Your Honor. My name is Crawford, and I'm happy to talk to you. After accounting for the state judicial circuit, effectively after filing the done. There is one issue in this field whether the trial court committed fundamental error when the court considered unsubstantiated acts during the sentence. Specifically in this case, the trial judge was provided aided to uncharged misconduct which occurred the day that the union scene was that police report was entered into evidence. The trial judge questioned the prosecutor about it.
And the trial court did do some questioning before sentencing, but what in the sentencing are we to look at to see that the trial judge did indeed rely and consider the uncharged act in sentencing?
Specifically, Judge Smith on page 215 in the record, the trial judge tells Mr. Weyrich, but there's times in your life with all the things that were going on in your life, you're selling drugs, you're hanging around drug dealers, they're shooting up the car, they're shooting up the house, they're throwing the gun, and we're living a bad life. I'm glad to know you turned to that statement. So,
Okay, so that's anything other than that statement.
other than that statement, the trial judge of the police report, placing the police report in evidence, specifically confirming it was prosecutor, Mr. Weyrich had disposed of the firearm that morning, and it was in residence. Got up that morning, located the residence, which was not on his person. And again, he and his fault were victims of that shooting.
Now, of course, the sentence that was given was 15 years, right?
It was.
It well within the parameters of the legal sentence.
That's right.
It could have been as much as 30 years.
It could have been as much as 30 years. And, well, the courts of the state have said it's not an appealable issue to appeal a sentence as well within the statutory guideline range. There's an exception that this court has recognized on numerous occasions when the trial court relies on unsubstantiated allegations of wrongdoing and imposing sentence, which as Smith Court did here.
So what's the remedy you see?
The remedy I seek is a new sentencing.
At the new sentencing hearing, what's the maximum sentence your client could receive?
That's a complicated issue, Judge.
Not that complicated.
I would submit that 15 years based on double jeopardy principle should be the max. Or that it could be.
There are specific, you don't argue that in this appeal, so it's kind of irrelevant.
Correct.
The new trial judge has got me right to have to figure that out. It depends on what might be moved. If you gave him a 14-year sentence, we're moved. I always thought, personally, I'm not doing research for you. I always thought the sky's the limit. Statutory max is the limit on remand. And if you have a client that believes the max is 15, it gets 25 or 30, you got a problem. Someone does.
That revealing confidence, as I understand the court's position.
I feel like a bad deal for what happened.
Doesn't case law support that it's an entirely new sentencing hearing that it isn't canon?
The novel proceeding.
The question of whether it is a novel proceeding is not, it's a complicated issue. It depends who the new judge is, depends on the evidence presented. It relies on all the. I don't think it's
We can soon do first.
I hope I understand the course of reasoning. In this set of circumstances, I would submit, based on the case law, I would say that 15 years the maximum.
Well, you're asking for a different judge. A different judge might have a different view of the evidence. New facts may come out. That's why they don't find the judge's hands to the original sentence. We don't know what's going to happen. Okay. Anything else?
Yes, Your Honor. Specifically in this case, the trial, it's not a situation, there's a whole written case law that describes how when the judge, there's an isolated mention of unsubstantiated misconduct, since the judge makes some specific statements or makes some specific arguments that does not encompass that in the opposing sense, esteemed as harmless. I submit that is absolutely. In this particular case, the trial judge heard about unsubstantiated conduct. We had a police report that was discovered with the defense counsel the day before the hearing. He specifically questioned the prosecutor on it. He referenced it during the sentencing, and I would submit to this court that she relied upon unsubstantiated allegations on this court and numerous other district courts appeal and found to be fundamental error. I respectfully ask that the court reverse and demand sentencing either before the same judge.
I'm going to give you 5 minutes.
Yes.
I apologize for not being able to hear everything you just said.
Tom Lawson from the Attorney General's office, so we have to stay.
Yes. Even better. Thank you very much. Welcome.
First, I'd like to address Judge Smith, specifically asking what did this court point to demonstrate problem relied on what is pointing to is statement that the judge read. I want to, I think it's worth us going through the statement because the first part of the statement is not about misconduct. The first part of the statement is charge conduct. Just 3 or 4 months before the incident, they was charged with possession of drugs, selling drugs.
But it occurs immediately following the sentencing, and it gives an explanation, basically, why the court did what it did. And so I think there's a little, I know the counsel pointed to this part because that was my specific question was during the sentencing. But there's other problems that I see in the record where to tie it in. You have the trial judge, sentencing judge involved in summarizing some of the facts with when the state relates the uncharged conduct. So you have a number of the court statements, and it's not just an isolated statement, it's a number of different statements throughout the record. And then you have the sentencing judge at the very end tie in the uncharged. I think with maybe just one, maybe at the beginning, maybe just one at the end, but when you have it both on both ends during the whole phase of sentencing, I think this really rises to the level of where the trial court was considering this uncharged conduct. So that's what I'm looking at. That this was fundamental error, and I know you disagree, but maybe you can help me consider with the state how we cannot consider it to be the trial court considering that uncharged conduct.
Well, again, and I think it's the word consider is being used loosely because when a court considers the misconduct, when the court uses that information, it's inevitably considering it. It's inextricably entwined. So we really have to point to in the record how the court actually denied or even waited. And in this case, there really wasn't anything point to demonstrate that the court gave the weight. Now, even during the sentencing, when defense counsel raised that it was going to seek youthful offender sentencing, the trial court specifically said, and that's at page 176 was something specifically said, we're going to wait to the end and we will address that. So if this wasn't a situation like you have where the love case was a couple of years ago, that was on the circuit, where this misconduct was a feature of the case. In the love case, there's a situation where there were 4 or 5 witnesses that were called and gave testimony about uncharged misconduct. That didn't happen here. There was no evidence that was presented to the court regarding discharge conduct. At the end of the sentencing hearing, the attorneys for the parties discussed the uncharged conduct. So the attorneys on witnesses, there wasn't evidence of that presented. And I think this whole issue got conflated where after all the witnesses testified, and the defendant came up, the defense counsel said, you're going to be seeking the youthful defender status, and gave all this information indicating that the defendant had turned his life around, he was remorseful, he was a candidate for rehabilitation. And it wasn't until the rebuttal that the state and
Use uncharged conduct, you rebut that.
and the judge's inquiry with respect to that information was really clarifying questions. There was something that came up in the case of the hearing where the judge noted that the address that was given for the police inquiry was different than the address where the motorcycle was hidden and these other issues came up.
You would agree this isn't a case like the Mercado versus State where there was actually no inkling, what the opinion wrote, no inkling that the trial court even considered any of that evidence or conduct that came in, because we have here a discussion after sentencing explaining, the trial court explaining why the sentence was given. And we have the uncharged conduct in the middle of that. So it's not like we don't have anything.
I do think Mercado was instructive, and I think that we need to remind you the judge's explanation for the sentencing. The judge specifically says that the reason the 15-year sentence was imposed was because of what the defendant did that day. Excessive speed, propelling the 7-year-old over 16 yards, killing the 7-year-old, leaving the scene and not looking back. The judge is very explicit in giving an explanation as to why the sentence was imposed. And I think where the judge comes back and asks questions about the misconduct, the information that was provided, I think those were clarifying questions. I think the judge hearing that information and processing it. But when you look at what the judge actually said in this ruling, there's no reference whatsoever to the misconduct. And I think that's what's important.
Well,
And
since you're throwing the gun in you were living a bad life. Isn't the uncharged conduct the facts about the gun?
well, I think you have to read that
Yes or
entire
no?
statement.
Yes or no? Isn't the uncharged conduct the incident with the gun?
Oh, yes, that's part of it. Yes, it is. And I think what's important in that statement is that the judge basically said, I heard what you had to say, heard what you had to say, defense. And at the end of that, the judge says, but that doesn't stop the ramifications of what you did. You have to, and I think the family said it, there's consequences for your actions. That's at page 214 and 215 in the record. So I think the court was basically, I've heard everything you had to say, but let's get back to the facts of this case. You were driving 63 miles an hour in a 30-mile-an-hour zone. You propelled a 7-year-old 16 yards, killed that 7-year-old, and you left the scene. And I think that in the ruling, the court is explicit and pounding those facts, not the uncharged misconduct. And I think that this court addressed that also in the McCarthy case, that you have situations where in the trial court is presented with all kinds of information. And in these sentencing
Well,
hearings,
there's a PSI file, correct?
yes,
There's all kind of stuff in the PSI
yes,
that might be considered hearsay or not admissible.
sure.
So and that came in without objection, correct?
It did come in with, it did come in without
So
objection.
we don't know what the judge considered in the PSI and what the judge said. I read the PSI, well, you're really a bad person. We don't know what the judge considered in sentencing, except the judge did specifically say, this is what you get for what you did that night.
Correct,
End of story.
correct.
So I can understand what the other side is saying. You can't unring the bell because the judge did hear a lot of improper things. There's a burden on the judge to then say, and by the way, all these improper things I heard, I'm not considering. Or the fact that he said, this is what you get for what you did that night, that automatically excludes those improper things from consideration of sentence.
Well, I'm glad you asked that question because the Supreme Court addressed that in Garcia. In the Garcia opinion, you had a situation where, the document was Wellington's and Brady's objection. And the court did not explicitly say in Garcia what it relied on within its ruling. But in Garcia, in that case, what the court did do, the court, I'm sorry for getting
That's okay.
my cases confused. I believe that was, just give me just one.
No, take your time.
moment.
I'm gonna mention one thing. When they do that.
Okay.
They're just, oh, if it's a totality of everything that happened, then we get to decide, which is not to say something correctness was not overcome.
Yes, that would have to be the analysis where there are any explicit statements. But in this case, there's an explicit statement that indicates that the court relied on what occurred that night. If you looking at a situation where there weren't explicit statements, you could look at the entire record. Love is the case where the example of what you gave before about parting out, saying that I relied on a piece and didn't rely on another piece. Love is actually that. Love is the case where the court specifically said there are two pieces of misconduct that we're not going to rely on. You say another piece, but it didn't say that it was going to rely on the other misconduct, but there were like 4 or 5 witnesses that testified with respect to the misconduct, and it was a feature of the case. And the court said, in looking at the totality of the record, they couldn't say that the court didn't rely on the uncharged misconduct. So that was the case. If there are any other questions, Your Honor, we will rely on our attorney.
All right, Robert, you got 5 minutes. Fine.
Yes, right. In respect to disagree with President as it relates to the trial court relying on uncharged misconduct. In this particular case, there is evidence that the trial court did. Specifically, she was asking questions about the police report itself. The police report was admitted into evidence. The police report references marijuana, which the court noted. The police report references disposing of a firearm. So there is evidence that the trial court did rely upon unsubstantiated allegations. And what the law says when this happens, the record reflects the trial judge may have relied upon permissible considerations in the opposing sentence. The state bears the burden to show from the record as a whole the judge did not rely on study consideration.
You don't think that sentence is enough? You don't think the sentence that we both quoted is enough? You're being punished for what you did that night?
I think if the entire record is read in context, all the statements the court made as well as the question of the prosecutor, in addition to the specific statement that was made in the opposing sentence.
What was the standard review of use of discretion or de novo in a case like this? You're arguing fundamental error, right?
I did, Your Honor, was a situation. This circuit, as well as the other district courts in appeals, say that it is fundamental error and a due process violation under Article 1, Section 9 of the Constitution, unsubstantiated allegations in this case. In terms of the standard review, in August of 2022, the Florida Supreme Court came out with Garcia, which says really it's objected to, fortunately, was Mr. Review case, all was required to review it for fundamental error. I would respectfully submit that Mr. Review case based on the brief on that side, fundamental error did occur in this case, it was a violation of the right. Respectfully asked, there is support for the person in the end. Unless there are questions.
Thank you, folks. Thank you both. Have a great day. Next case, we'll talk to you. Yeah, round to back.